rather dated the 12th of January 2026. Most importantly, in respect to order number A.
This is the decision?
That's the order. My Lord, the order reads that a conservatory order is hereby issued suspending the engagement, procuring, continuing to procure, paying bills, all engagements of private advocates, firms, by all public entities, when there is already a hired attorney general. So council is seeking to know the import of these orders in respect to these proceedings, and most importantly, the question of the representation of the first respondent. Could they be deemed to be represented in the existence of this conservatory order? And the reason why council sought for this because, and he avoided to make an application, is because there already exists an order, my Lord. I'm also good.
My Lord, Dr. Adrian Kamodo for the respondent, we are yet to be supplied with the order that is being referred to by council.
Can we start with the first? Yes. We'll come back to you. First to third respondents.
Yes, my Lord, Charles Mongela for the first, second, and third. My Lord, there is no application which has been placed before you. There is no formal application placed before you seeking to bar counsel before you, who is appearing for the first, second, and third, so that we can see from the material in support of that application and take instructions accordingly. My Lord, furthermore, at the taking of directions, because of the nature of this kind of matter, which is an election petition, which is time-bound, parties intending to file any preliminary applications or objections are supposed to bring them beforehand, so that we are able to take them into account in the directions. As opposed to, my Lord, fishing cans under the table and is bringing surprise at the taking of directions. My Lord, the right to be heard, the right to be represented by counsel is entrenched in the Constitution. So this is a matter you need to place before you have formal application. We are going to be responding to that, my Lord. Thank you.
Kamoto, I think you were on your feet.
Yes.
That's counsel for the first to third, and you are the fourth.
Yes. Yeah. So initially I was seeking to be supplied with the order, yes. And been able to peruse the order, and the terms of the order are very clear. They are very categorical, that it is suspending the engagement. So this order does not in any way terminate existing arrangements. It's precise, it's clear, and there is no basis for the application by the petitioners, because the services of Mr. Mongera were not procured subsequent to the issuance of this order. This order is dated the 11th of January 2026. From the record, it is discernible that the counsel for the first respondent had been engaged by them. So it doesn't affect the counsel for the first respondent as we speak. I'll yield to.
Yes.
Yes, my Lord.
Counsel.
It is therefore not denied.
Your name, please. Don't forget to say your name.
Sorry, my Lord. Sorry, my Lord.
For the transcript.
Sorry, my Lord. My name is Kiragu Atuta. It is not therefore denied that the order exists. According to Mr. Kamotho, the order would have applied to Mr. Mongela if the services were sought after the order was made. So whether that order prevents such services being rendered to an institution which procured the services before the order, that's an issue that needs court direction.
Yeah.
It's an order which has attracted a lot of public discourse, including our own society, Law Society of Kenya, issued a statement through its president on the import of this order, because it is said it freezes all the business that lawyers are conducting. So there's no advocate then who can say that they were not aware of these orders. I was just checking whether Mr. Kamotho, who I normally follow on social media, whether he commented, but unfortunately he did not comment on this order. So basically, there's no need for a formal application to bring this order to the attention of the court, even as we got it just the other day. And it is upon us as officers of the court to bring this important information before the court so that the court can see where we lie. In fact, I'm being informed, the Law Society of Kenya even sent an email to all its members, including ourselves, including the ones that are before you, on the import of this order. Lastly, on the suggestion that the order only applies to services procured post the order, that's not correct. My Lord, I have no doubt that when you look at this order, you'll be able to see the wide terms in which it is framed. It talks even suspending the engagement, then procuring. So procuring and engagement are totally different. So Mr. Mongela is engaging with a public body. Those are two terms in this order. Continuing to procure, even continuation. Even pending payments, Mr. Mongela will not be paid. All engagements of private advocates, including coming to be able to attend this matter, where there is already hired an attorney general, state councils, and goes on, and the county government. In fact, my Lord, the Association of County Attorneys issued a very strongly worded statement on this because it more or less freezes their business. We have people, I know the Law Society is seeking to vary or set aside this order, but as far as until it is varied or lifted, there's still that challenge. So, my Lord, we humbly seek your directions on this so that then we conduct proceedings that do not violate another court order of a different court. And that's all, my Lord, from me. Mr. Mbeere.
My Lord, just to add on one thing, the council has failed to address the question that has been raised by Mr. Mongela on the right behalf. My Lord, the judge who issued this order was alive to that fact. And that is why he's saying that the only persons who are barred from appearing and representing public bodies are private advocates stroke law firms. Then he goes ahead and says, when there is already an hired attorney general, state councils, solicitor general, and the county attorneys. So he's alive to the fact that such an order may create an hindrance to the access to justice under Article 50. But he then says, even when an order such as this has been issued, there is another body providing similar services. So Mr. Mongela cannot say that his client will be prejudiced and the right to a fair trial under Article 50 will be compromised because there is already an existing alternative.
Okay. Counsel, you know what you've done is you really argued an application which is not before me yet. That's essentially what you've done. So the direction is very simple. I've just had a quick look at the order. And I think item E in the order is the one that you are referring to.
Yes, Your
Item E.
Lordship. Yes, Your Lordship.
First of all, I'm not sure myself I even understand the order. where it says a conservatory order is issued suspending the engagement, procuring, continuing to procure, pending payments. I don't know how that fits in. All engagements of private advocates or law firms by public entities when there is already hired attorney general. Hired by who? There's a whole question of interpretation here. Can you please file a form, or this is the direction I'm giving? Petitioner to file a formal application in relation to the request for, I don't know whether it's a request for clarification by this court. I'll call it a request for clarification by this court as to whether the IEBC is properly represented by the council on record, the council presently on record. All right. How much time do you need to file that application?
I would file it by close of business. It's now 12. By close of business tomorrow. And I just come
Tomorrow
allowed.
is the 16th?
Tomorrow is 16th, yes.
16th. And service, same day?
Yeah, same day, my lord.
Any of the respondents want to respond? First to that?
My lord, I was even suggesting a more efficient way to Mr. Mongela. Because we really want to move the matter.
Don't forget your name is...
My name is Kirago Aduta. My name is Kirago Aduta. Perhaps he can just have counsel who is within IPC to be on record, then we can work together, just so that we don't proceed and then we just go back. That's a more practical solution, so that one of the advocates comes on record, then...
Yeah, but you see, I'm not going to stop work because of this.
Very well, my lord.
We will finish with our pre-trial today.
Yes.
All right? I've also noted this order was made on 12th of January.
Yes, my lord.
So I don't know whether it has effect
Yes.
backwards. I don't know.
Yeah.
These are some of the things you will tell me.
Sure.
And I'm trying to bring me all sorts of authorities and saying that...
we'll get away out, my lord. We'll get away out.
So, respondents, first to third.
My lord, I'll be requesting you give us, this is Charles Mongela for the first, second, and third. You give us until Wednesday.
I don't have a diary or a calendar right now. What's the date?
Wednesday next week will be on the 21st.
Yes, 21st.
File and serve your response by COB 21st. Fourth respondents, are you participating in this?
My lord, you can file, this is Gachuba, you can file our reply by the same Wednesday.
Can I suggest that, just so that we can speed this up a little bit, you file your responses with your submissions, your application maybe the...
I'll also do with the submissions. My name is Kirago Aduta.
You can do it with submissions.
Yes.
I'll limit your submissions to 3 pages, to which of course you might want to annex your authorities. duly highlighted authorities to be annexed. Okay. So I think we were on the question of, we are still on the question of pleadings. So we've dealt with the pleadings of the petitioner. I know there are other pleadings like the application, the notice of motion. We'll come to that in a minute or two. Are these pleadings filed in soft form? Your pleadings?
Sorry, my lord?
Pleadings, are they filed in soft form?
Yes, they are, my lord.
No. I mean the pleadings themselves, are they also in soft form?
Yes, the scanned one. We have not filed the Word version, which we can supply also.
It's just to make it easier for us to copy and paste certain information whenever it's necessary.
Yeah, I can have that done right away.
There's no emergency. You can do it in 7 days.
Very well, my lord.
Yeah.
I'll do that.
And the same for any future pleadings. Just put them in soft form, also in Word format. Respondents, first to third respondents.
My lord, perhaps before the respondents engage with you, and I would beg to be guided by your wisdom.
Yes.
The direction that we just issued about the application
Yes.
in regard to the import of the orders that have just been brought to your attention.
Yes.
My lord, I am really begging to be guided by the court whether the trial can still continue.
It is.
When a challenge of representation has been posed to the court. Because representation goes to the core of even the pleadings that we are just about to address you on. My lord, while I am aware that I'm at the bar, would it, my lord, be prudent that this application be determined first, so that the directions that will ensue from these proceedings will not have the possibility of being hindered by the subsequent ruling that you might give? Because you may find that Mr. Mongela is not properly on record, or you may find that he's properly on record. What shall we do at that particular time?
What I am going to do is this. Of course, I don't know what the outcome will be, but I am not going to jeopardize the petition on the expectation that the IEBC may lose their counsel. So we will proceed. If this is a nullity, let it be said in the Court of Appeal. Correct? It will be said in the Court of Appeal, or by myself. If what we are doing is a nullity because of the absence of IEBCs,
I understand it.
you understand what I'm saying?
Yeah.
So let's not jeopardize the 6 months that we have. They're actually now no longer 6 months, they are less. Let's proceed, and then when we come to a point where I have to drop my pen, I'll do so, if I have to. There is in fact another application, I think, for me to drop my pen.
Yes, madam.
Isn't it? But I have to determine it also, isn't it? I can't drop my pen first, then say it needs to be determined. All right, so let's go back to respondents' pleadings.
Yes, madam. We have found our response together with the affidavits. My lord, we also confirm the materials are preserved, the electoral materials are preserved at the IBC Embu office.
Yes.
My lord, regarding the register, because the petitioner also filed a register, we felt that it would be prudent for the IBC to file the register also, because it is fairly bulky, my lord, and if it were to transpire at some level, it material contained in the petitioner's bundle is not what the IBC believes to be the register, then, my Lord, the best way to counter-check that would be by them relying on their filed register. So, my Lord, I have indicated in the affidavit, because of the challenge we were having in compressing the soft copy, that I would be availing it in hard copy, but in due course, we will be uploading it as well, the register. Otherwise, our pleadings are filed. We have also.
Have you looked at their register? The register that's already been filed?
I have looked at it, my Lord. As you can see, my Lord, we were just served last week, been working up to sometimes midnight to go through this document and come up with a response. I will not say we have been able to really interrogate what they have. We just looked at their register very, very casual, in a very casual manner, my Lord. Therefore, in the interest of time, the 7 days timeline, we decided to bang in the register ourselves. So I'll be bringing in the register as well.
So you'll be filing the register within 7 days?
Yes, ma'am.
Okay. Fourth petitioner, fourth respondent. Pleadings. I think you filed some things today.
It's Adrian Kamodo for the fourth respondent. We have filed a response to the application, to the petition. The same is dated 14th of January 2026. We have equally filed a replying affidavit to the application dated 22nd December 2025. The affidavit is sworn by the fourth respondent on 12th January 2026. My Lord, the responses we have been able to do are based on the material that we were able to access from the portal. We were not served by the petitioner.
You are not served.
We were not served, but we endeavored to Yes, I understand there are some volumes that were served to my counterpart, but there are some items that are missing from the documents. There are annexures number 9 to 28.
So can we say that you are served with the petition?
Yes, we can confirm we are served with the petition, albeit with missing items.
Some annexures are missing.
Yes.
Just identify them, please.
Specifically, annexures number 9 to number 28. And page 30 of the petition.
9 to 28.
Yes,
annexures and
that's
page.
annexures. And then there is a missing page in the petition. That is number 30. Page number 30 in the petition is missing. We have also not been supplied with the video clips, and that was confirmed by Mr. Watuta. We shall therefore be seeking to be supplied with all those missing elements, so that now we are able to comprehensively address the petition. So basically what we have filed is a holding response. It's an interim response because it may change once we have been fully furnished with all the documents underpinning the petitioner's case. So we shall be seeking leave to file a full response upon being served with all the missing documents and annexures. And equally to serve, and equally we shall seek leave to file witness affidavits as may be necessary once we have been fully facilitated with the complete set of documents.
So what I understand is that what you are working on is not actually the petition.
It is the petition, but partially because now there is information that we do not have, which has not been made available to us,
That is the
which
missing.
may alter the trajectory of the response once it comes.
That is the annexures on page 30
Yes.
and the video clips.
Yes, and the video clips.
But you have the petition itself.
Yes, the petition saved for the page that is missing, the page number 30.
Mr. Waluta,
Yeah.
you have not served the petition?
My Lord, we did. We served soft copies first. Then all of them have hard copies. Mr. Mongela's hard copies are actually here. Mr. Gashufa was served, he works at Harambe House, 4th floor. My person went all the way and served hard copies. Mr. Gashufa, you can confirm that. Yeah, he was served. And there were 3 bundles, 3 very big bundles. In fact, one of them is a voters register, which council has confirmed and they have it. What Mr. Kamoto has suggested is that annexures 9 to 28 are missing. But then, again, he says those are the video clips. Actually, they are not the video clips. Annexures 9 to 28 are documents. The video clips are elsewhere. So, if it is a flash disk which was applied, I still have another one, even here, which I can still copy for him. So that by the time we
What
leave.
he said, as
Yes.
I understood it, he said some annexures are missing, that is numbers 9 to 28. Annexures 9 to 28 are missing. And also page 30 of the petition, plus the video clips were not annexed.
I can see supply, but the bundle itself, this one, has those documents. I can see supply, but they are there. They actually annex just one affidavit, the supporting affidavit. I'm still willing to supply it, nonetheless, even today. I'll just make copies of that.
Yeah, Mr. Kamado, just, there's 2 of you acting, and I think you came at different times. Might there be a confusion between the 2 law firms?
No, there's no confusion because the document is here and it's visible. It doesn't have page 30. The document is with us.
Malo, the document is very big. It
So
is.
the page 30 is missing from the document. So that doesn't warrant any sort of reaction. It just supply the document. Then, my Lord, I have stated that annexures number 9 to 28 are missing. We don't know what they are. Video clips are also missing. We don't know the contents. So if it can be supplied with those ones, then we'll be able to know the nature of the content, whether they are video, whether they are pictorial, and we respond accordingly.
My Lord, I'm just trying to assist the court. And I noticed there is that disconnect. Mr. Gashufa actually has the file here with the big bundles, which was applied to him upon request at Harambe House. So it cannot be in that small file. So if you can just retrieve those documents, they are there.
My Lord, allow me to respond. This is Kachuba. The petition is paginated 29, overleaf is 31. So there's no 30.
Is that the same in our bundle? Is there page 30? Petition itself. Okay, so there's a page 30 and there's a page 31. So yours 30 is missing.
Yes, it's missing, and it's overleaf. So it cannot, it's 29 that one is paginated. And for clarity, my Lord, the documents that are here, this bundle is what we printed from the portal. This is a different one from what was served. So it means that these documents are also missing from the court record, and it would be necessary to ascertain. Because from the portal, we could also not get
Well,
the annexures.
at least page 30 is in our document, the hard copy. I don't know whether it's missing from the printed out version. Just a minute, Council. Let's check what we have. On the petition, page 30. Okay, our printout from the portal has page 30, and the hard copy bundle that was served on us also has page 30. So there may be an issue somewhere else, but that is for you people to sort out. Eh?
I can
Your,
still give
your
him.
officers of the court. I don't
I'll
know
still
whether.
give him. I'll still give him, my lord.
All right. Let's say
My
the
lord,
direction. The direction is as follows. Let's not engage too much on this. Let's finish this discussion. Petitioner to serve the full petition afresh on fourth respondent. All right?
Just,
Or is it just the pages?
just
that
the
are missing?
page 30. This thing is very costly to make up. Mr. Kashufa knows. He spent the whole day with my clerk doing that work.
my lord, there is a fundamental issue. It would appear that the document that the court has are not the same document that we have been supplied with.
No, this one is printed out
Yes, the
from the
same-
portal.
Yes.
So this one, as far as we are concerned, we have the full document. What I didn't see here were some of the annexures which were here.
Can you confirm, my lord, whether it has a page 30?
It has, we just looked at it.
This one doesn't have page 30, the one you have.
I can't help you with that.
So that's why your order should hold that they serve us with the document, a replica of what they have filed in court.
Yeah, my lord, this is something that we did. And in fact,
Don't forget you have names.
my name is Kirago Adhuta. If it is only page 30, and Mr. Kashufa knows what we went through. And my lord, just for context, Mr. Kamobo came on record first, and we served him. Then later we saw another notice of address by Mr. Kashufa. So we went now started dealing with Mr. Kashufa. So whether they have coordinated that transition, I'm not sure. But Mr. Kashufa has all those documents. If it is page 30, I'll give him right now.
I'll give a direction in a few seconds.
Only that, my lord, if you may, we might be invited to run to a risk by Mr. Kamodo's invitation, and if the order were to say that we serve, because the rules of service are very clear, and most importantly, Rule 10, so that then they may not say, we have just been served, we need to do a reply. I have heard him try to amend the rules by indicating that what they have on record is interim response, something that is quite alien in law or in our rules, so that then we only provide the missing page for purpose of fullness of record. But we are not serving because we have served, and therefore they will not be seeking for leave to put in any other reply because the reply has been served already.
Let me give my direction. You are replying to something else that has been raised.
I will not respond to that because I will simply say that there is no affidavit of service on record. So no service has been.
Just
My lord, it is already filed, it is on record.
Counsel, please. I will not accept the kind of interjections that we have in here. We will not proceed this way. Okay? You may be able to do that when you are doing your politics, but not here. All right? I will begin to, I have my gavel here. I don't like to use it. When I use it, it will have a meaning. Okay? So please, let's take it easy. There's no war. We have 6 months, and we are going to finish this in 6 months. Okay? We will do it. I have all the confidence in all of you as officers of the court. There are some things that don't even have to come to the court for directions. Some of those things you can sort yourselves out as officers of the court who have taken an oath to assist the court in accordance with the Elections Act. Correct? I think that's the way I'm going to treat this case. So let me give my directions, which are as follows. Petitioner to file, to serve pages pages 30 of the petition, missing annexures 9 to 28, and video clips, or video clip, within 7 days. Now, all pleadings that are pleadings, please don't forget that we also need them in soft form. In soft form. Has any party seen from the documents filed so far anything that is illegible? Any documents that are illegible, which you would like to point out at this point? I'm looking at item number 5E.
On the part of the petitioner, we have not seen any.
Okay.
Perhaps because we have not been served. I think we'll be getting the documents. But in case of anything, we can resolve it among us council.
And you can still raise it. This is the first pre-trial.
Yes.
There will be opportunities for us to raise any issues which are concerning us, which are bothering us as we go along.
Yeah. Anything I can always raise with my learned friends.
Anything that you've seen that's illegible?
Yes, Adrian Kamodo,
Yes.
for the respondent, we have the register that is not legible, as is here.
I had challenges myself reading the register. Let me not pretend that I read the whole document. So that, I just perused, a quick perusal, I flipped through. Yeah, I can't. I think it's a scan. Is it a scan?
We were given an Excel, and then we just converted to PDF. What was given to us in a flash disk. We just got a soft copy, then we converted to PDF.
Yeah. Are those pages illegible, or is it that they are not as clear as we'd like them?
Yeah. But my lord, because we have the register in a flash disk that came from IBC, we can still supply it to court, so that then whichever pages you'll be referring to, the court can easily go and magnify or expand.
Page 24, 64 and 65 and 66 of the petition appears to need a bit of help for clarification.
Sorry, volume 3. Page?
24, 65 to 67.
2460.
No, to 66, sorry, to 66. 64 to 66.
2466. Yes, my lord.
It's a photocopy and it's not legible in aspects.
Sure. We can supply clear ones.
Yeah.
Yeah, we have the originals. 2464, 2466.
Okay. It may even have no bearing on the actual case, but let's have it clear.
You do that, my lord.
Now, I'm moving to item number 7. Sorry, IBC. I don't think I had you say anything about clarity of any documents. Are there any documents you struggled with?
No.
Reading? In terms of
My lord, if I come across any appointed, none at the moment.
Yes, Council.
My lord, and sorry for taking you back. About the register, I had made a request that we supply the court with a soft copy as received from IBC, so that just in case the court needs to refer something, can just expand on the screen, because we have an Excel. It's an Excel? Yeah, it's not, yeah.
You
it's an
obtained
Excel.
it from IBC.
Yeah, they give us a soft copy, which we can supply to
The
court.
original register is probably with the materials which are preserved.
We will be supplying, my lord, we will be supplying
The original.
the register, a physical copy as well as a soft copy.
Is the original register available?
Yes, my lord, it is.
It is.
Yes,
Okay.
yes.
So what you want to make is a photocopy of it?
We have it in the system. We generate, because even the petitioner, my lord, what he could have done,
Yeah.
which I'm not aware whether we did that, was they were supposed to apply for the register from the IBC and they pay the requisite fees, which apparently I'm informed may not have happened. And that is what part of the reasons why I'm insisting on filing the register myself.
Okay.
Yes, my lord.
Yeah, my lord, Kiragu Aduta, for the register, indeed, we applied formally and paid a fee of 20,000 shillings. We have attached the documents to show the chain, how we got the register.
Let me make an order for IBC to avail the register to court and parties in soft form, to parties in soft form, to the court, let there be an original. I'm looking at F now, 5F, trial bundle. I know that would be an expensive process if we go the way we sometimes want to go, which is to prepare, each party prepares the document that they will be relying on at the trial. There are lots of other papers in the file which we'll have dealt with. Like all the applications, we'll have dealt with the applications before then. So are you willing for us to have a trial bundle? Petitioner?
No, they are too bulky to consolidate.
bulky.
Yes.
All right.
My lord, we intend to, because mine is paginated in batches, I wanted to file a paginated bundle, a complete bundle. I'll be doing that.
Fourth respondent.
Adrian Kamodo for the respondent. We will also file a trial bundle, properly paginated, and we will also be seeking that the same applies to all the parties for uniformity of the court records.
Now, I know your trial bundle, 80% of it is the register.
Yes, my lord.
If I ask you to omit the register,
Yes.
we know you have filed the register.
Yes,
We will
madam.
have the original register from IEBC.
Yes.
What you have filed is still there in case there's a difference between what IEBC gives to the court and what is contained in your documentation.
Yes, my lord.
Can I ask you to file a trial bundle without the register? That's the only thing that will be missing.
Yes, my lord. I'll do that. By trial bundle, I thought is what we normally do, a consolidated bundle of all the pleadings
All pleadings for trial.
for
I
trial.
don't want it for applications.
Yeah, so that then if we file separately, we'll have 3 separately or differently done trial bundles. So maybe we can just say, as we do the petitioner's trial bundle,
course.
each party to do their trial bundle.
Oh, of course.
That one, my
Of
lord,
course.
will do.
Yeah,
That
yeah.
one will do.
That's the way it would be done. I wouldn't expect you to do a trial bundle for them.
Very well, my lord.
You
That
might
one,
put in documents they don't want to use.
that one will do, my lord.
Okay.
We'll do that.
So it's a trial bundle then for each party? Can we say how long? How much time? Is 7 days?
That's enough.
7 days. Within 7 days. G, deposit of security for costs. I think that was done. I have seen the receipt. Is there any issue on that one?
My lord,
Let council speak.
Well, I was trying to guide you because I had to raise the issues. I was reminding that we are dealing with petition number 2.
Okay.
no, I was just raising something before we move to security for deposit.
Yes.
On the time interval for the trial bundle, noting that we may be supplied with new documents and take time to prepare something.
I'll give you 14 days. Let's do 14 days.
Very well, my lord.
There's no emergency. We'll be dealing with the applications in the next number of days, or maybe first 2 or 3 weeks. So the actual trial will begin a little later. So let's do 14 days for the trial bundle. Deposit of security, is anybody objecting to that deposit? Has anybody not seen that the deposit was filed? Okay, let's move on to the next item. Court proceedings and transcript protocol. I don't know whether the ICT people have already issued you with the standard operating procedure for how to speak in court and how to ensure that you are heard. There was a document I saw. Yeah. Have you been given a copy of that document? You have? All right. The guidelines for digital recording. So we can see that has been done. You will also be responsible for ensuring that the parties that you are representing and the witnesses understand that they have to speak up, speak into a mic, say their names every time they speak. Can I take that as agreed?
Yes, ma'am.
Transcripts, I think we mentioned this earlier. The transcript of proceedings will be available on the second day. So today's transcript would be available on Saturday, but probably available to you on Monday. You have an opportunity to look at it. It will be a transcript, so I don't think there will be too much argumentation on it. I don't expect there to be. You'll have an opportunity to look at it. Just in case we have missed a whole page, you will let us know on the third day. That's what item 6C2 refers to. 6C2. If you want a printout of the proceedings, I understand there's a cost of 60 shillings. Is that still the same? It's 1,000 per page for the whole proceedings. Oh, you should charge it, make a better deal than that. So it may be very long. Okay, so it's 1,000 shillings for all proceedings, for the full proceedings. As I indicated, I will be writing proceedings such as I am doing. They will be notes rather than proceedings, which are personal. Let's look at some pretrial matters. There's a question of mandatory consolidation. Because the two petitions, number 1 and number 2, relate to the same election, they should be heard at the same time in the same hearing. Now, you want to speak for me?
Sorry, my lord, I thought you were done. I wanted to rise on.
No, I am not done. I'm going to make a suggestion. I have seen that there's an application to strike out that petition. And submissions have been filed by all parties other than the petitioner.
Yes, madam.
So my presumption is that given the clarity of the law on that question of deposit, I do not expect that that matter will be proceeding. Is that correct?
That matter in terms of the petition?
Yes. Petition number 1.
My Lord, we have put grounds and we have explained the reason why we are here, where we are. And it was anticipated that at this point, the two petitions will be consolidated because petition number 1 is one item in petition number 2. So that then upon consolidation, that issue of the security deposit, which has already been deposited in number 2, will be moot.
Yeah, but petition number 1 has no security deposit. That petition cannot be consolidated because it does not comply.
Very well. Maybe what you can do, the issue of security.
In fact, I was going to make it very easy for you.
Yes.
I was going to say, instead of us taking a lot of time on petition number 1,
Yes.
which is subsumed in petition number 2,
Yes.
withdraw petition number 1, and we'll deal with that question which you have raised in petition number 1 in petition number 2. It's the same question, isn't it?
Yeah, my Lord. Yeah, that's what we are consulting here, and
I can give you half a minute.
Yeah,
Just
we actually
consult and agree.
in 1 minute.
Yes, my Lord, that would be sufficient.
Yeah.
Who is the lead counsel?
I'm present, my Lord.
Yeah, just give me one answer from the.
Yes, my Lord. We would go with the option of withdrawing petition number 1, which application we hereby make, and having those issues subsumed in petition number 2. And with no odds as to cost.
I have a bit of a challenge.
Yes, my Lord.
Petition number 2
Yes.
takes over some of the items in petition number 1.
Yes, my Lord.
Those are the ones that are subsumed.
Yes.
When you say that it is withdrawn, but the items in it are taken across to petition number 2, there's a bit of a difference.
Yeah, my Lord.
What is in petition number 2 is what we will continue with.
That's fine. We can still argue. Yeah. On our side, we can still argue those issues in number 2. So I think we can just make it simple for you.
Petition number one to be withdrawn.
Yes.
In your case, you would pray that it be without
cost, my Lord. And just for clarity, I've not seen a response from Mr. Kamotho. At least he hasn't filed in response to that application, to that petition. And Mr. Mongela has not submitted with any response to that petition.
Okay. So your prayer is for it to be withdrawn with no other costs. First, third.
Sorry, Kamoto now.
Oh,
Yeah, my Lord, I'm just being informed, just sorry for taking me back, and that the clients are present in court. Maybe
in petition 1.
in petition number 1.
Yes.
So just for good order, when we take a break, we just consult them before that application is dealt with, so that then we are on the same line, because we may not be able to make a full decision here. I see the
in court here.
Yeah, I can see the wisdom in it, but then maybe the petitioner will see it differently.
All right. So you want us to delay this decision on consolidation?
On consolidation, my Lord.
We can pen it for a couple of minutes. I don't think I'll give you too much time. I think one of your council should go out with them and have
Yes.
a discussion
We'll do that.
so that we are not going to delay what we are trying to do.
Indeed, my
Today
lord.
is a pre-trial.
We will not delay.
That was the first petition that was filed. In fact, the date of today was given in line with petition number 1, not
Yes.
2.
Yes, my lord.
So petition number 2 had to come in, although it is very much later in terms of time. So one of your council will have to go and have a chat with them, and then you'll come back to me while we are dealing with the other items.
Very few minutes, my lord.
My lord, before they are discharged, we have an objection to that line of progress because the file before the court is E002 of 2025. Counsel for the petitioners has raised issues relating to a file that is not before the court.
That's what, council. Really, you are splitting hairs. I know we are dealing with petition number 2. Don't think I am so poor in my understanding as to not understand that we are dealing with petition number 2 and that I am the one who raised the question of consolidation. Because it is a requirement in the law. Petitions of like parties to be consolidated.
My lord, I'm in agreement. Allow me to make my point on
Yeah.
that. My prayer is we deal with the issues in the file number 2, and since we'll be going back to file number 1, because as it confirms the parties are there, we deal with the issues there comprehensively, because we have applications pending in that file. We have applied to strike
That's
it out.
fine, counsel.
So we pray
That's
that.
fine. If you like, we will even go through the whole process, the whole of this process in petition number 1,
I so pray, my lord.
if you like. But for now, I'll give, for petition number 2 to be complete, is it going to be consolidated or not? And I will need to have an answer to that.
In few minutes, my lord.
All right? Issues. We are looking at page 4 of 7. Contested and uncontested issues. I think it may be a bit early because I saw the response today from 4th petitioner who is indicating in any event that you have only filed a holding response. Is that correct?
That's correct, my lord.
But let me tell you what I see to be the issues. I think in petition number 2, one of the key issues will be whether the 4th respondent was eligible to contest. All right?
Yeah.
That is one of the key issues. There may be some sub-issues in it, but I think that is a key issue. The second key issue is whether the overall outcome of the election reflected the will of the people. And under that, there are also a number of sub-issues, for example, irregularities in counting, sourcing of the wrong personnel, and so on and so forth. All those, they're all in the petition. Other than those 2 key issues, is there something else that the parties really think this court will be determined?
The
Yes.
standard one.
Hmm?
The standard one. We shall bear the costs.
Okay. For that, as when we come to the towards the end of this, we'll even discuss how costs will be dealt with. Okay. But those are the 2 key issues that I sort of saw, and I know there are sub-issues in them, so that we are not straying too far from what is the core of the case. Is that correct? Adrian Kamodo, you don't look happy today. I want you to be happy, to smile for the camera. As an officer of the court. Are you okay? You have something to say?
Well, I'm hoping that the court finally will put a smile on my face.
Okay. You mean at the far end? All right, we'll see.
Yes, my lord, I think we can have those as the major issues.
The 2 major issues. Okay.
With sub-issues, as you say.
There are sub-issues. Any counsel with a different opinion on that? Including, of course, the issue of costs, which we'll come to towards the end. Then now we need to identify the interlocutory applications that have been filed. The first one is the one in respect of which we have just made some directions. It's not actually the first, it's the last, because it was raised today, and the application itself has not even been filed. But there is the certificate. I think it's here. The notice of motion and certificate that came up on 22nd December by the petitioner.
Yes, yes, Lord.
And I think I only dealt with item number 2 in that notice of motion of 22nd December.
Yes, yes.
Items number 3 or prayers number 3 to 9 are yet to be dealt with.
Yes, my Lord.
So those will be the subject of responses and directions today. Can we give directions?
Yes, we can.
Okay.
And perhaps maybe I don't know whether there is any that is objected, because if he's conceding to some, then or all of them, then we don't need to do much.
Let's see. On applications, that is a notice of motion dated 22 December. Prayers 3 to 9 are the ones which have not been dealt with. Directions. Are these challenged?
Yes, my lord.
Yeah.
The application is challenged.
Yes.
Yes.
So they are challenged, Mr. Kamani?
Yes, Adrian Kamodo for the fourth respondent. I confirm their challenge.
They are challenged. So let's me give directions then on the responses. How much time do you need to file a response? You've had this file now for a while.
Yes.
How much time do you need to file a response to that notice? Seven days.
Yeah.
Because
Rejoin
it's
the which is
rejoined.
spoken about, then we put in submissions.
Okay. Let's don't forget we can do anything we really want. Eh?
Yes.
Yeah. But I see the sense of doing it that way. I'm sure it's the same for you.
Yes, yes, my lord.
So let the rejoinder by petitioner be filed. I think 3 days should be sufficient.
For the
Rejoinder. The application is yours,
yes,
so you have all the information in the world.
Yes,
You've had
ma'am.
it actually since last year.
yes.
So you're just finding a response to what they are saying in reaction to your.
Yes, my Lord. I can squeeze myself. It's only that now that I'm doing together with submissions,
You have so many.
I was seeking
That's
some
okay.
grace. Very well, my Lord. 3 days is okay.
Within 3 days.
Yeah, I can do that.
Because we want to hear all the applications and maybe more may come as we go along.
Very sure. 3 days.
File within 3 days, filed and served.
Yes, my Lord.
Of today's date. Together with submissions.
Yes, together with submissions.
Just give me the diary, please. Let's see how it goes. Have you filled in material? Other matters of the hearing? Already. Respondents' written submissions, how long?
My Lord, we are ready to do that 3 days upon receipt of the petitioners, applicants.
Same, come on,
Same for us.
3 days. Within 3 days after being served. I think we may want the submissions to be a little lengthier this time, because I think the number of items and the gravity is a bit heavier. Is 7 pages sufficient?
Yes, my lord. I think even in the Supreme Court, that is usually the limit.
7 pages.
Yeah.
Submissions limited to 7 pages. 7 pages submissions?
Yes.
7 pages.
Yes. Fine.
To which authorities duly highlighted shall be annexed. I think we may need to highlight these ones because we are referring to documents, lots of documents. We are looking for scrutiny. We are looking for recount in some cases. So there may be a need for you to demonstrate to me through your submissions what your documentation says. I'm talking about the petitioners.
Yes, my Lord.
Yeah.
When I saw your directions, my Lord, I was hoping the question of scrutiny could be determined in the trial. Sometimes we got
In the trial.
there can be
But
substituted.
if they can make a case for it now, why not? They have an application.
Fair enough, my Lord.
That application includes an application for scrutiny. I hear you.
Yes,
We can still redo it
yes.
at the time of the trial if the justice of the case requires. There's nothing that we can't do. Yeah, but I understand what you're saying.
And I again beg to be guided. I want to borrow the wisdom by counsel for the IBC that we have to lay the basis why we need to either have scrutiny or recount. My Lord, would it be sufficient enough to lay the basis through the affidavit, or we might have to have the witness at the dock and lay the basis why we need recount or scrutiny in a particular polling station? Because basis must be laid, and that will be jurisprudence. And if we take at this time around, will it prejudice our case as a petitioners?
I actually have 2 options. If I decide that the petition outcome, that the 2 parties are very close, I don't have to have a basis laid. And that's our jurisprudence too. So there are cases where 127 votes was considered very close, and therefore no real basis has to be laid. In this case, you have about 495, 494. The difference is 494. I'm not sure whether it is too close or whether it's very far. Is too close less than 100, or is it more than 100? It's a discretionary point. Mr. Kamodo.
Yes, I can respond to that question.
Yes.
Yeah, there have actually been smaller margins than that, and the winner has always been declared to be validly elected. So
It's
those
true.
those small margins are common
No,
in that part of the
We are not
country.
talking about the outcome of the scrutiny. We are talking about whether or not scrutiny should be done or recount. So you can have a case where the difference is 10, and the person who was elected at the first instance remains elected. Is that what you're talking about?
I'm in agreement with the perspective by the court. I think it's true. It's
Yeah.
possible that even the margin is 2 votes, but
Yes.
still the process is sustained.
Correct.
Yeah, my lord, we've just whispered with Mr. Mongela, and we've also agreed that after we leave this place, we'll also continue to engage and see which parts of the application can be resolved as you go along, so that we don't have to submit too long on things that can be settled.
Excellent.
Yeah.
Thank you. That is exactly what we are looking for.
Thank you.
That kind of cooperation between you as officers of the court. Sometimes you are always fighting.
Yeah.
And I know you are fighting for the rights of your parties.
Indeed.
That's totally understandable. But you are now, that is real assistance to the court.
Thank you.
Yeah.
Thank you.
So should we retain the orders the way we have done them?
We can, my lord, we can, but the challenge I was finding is,
Yeah.
if you look at the nature of scrutiny which is being sought,
Yes.
it is not just the scrutiny of the ballot. There is sought therein, my lord, scrutiny of the system, the technology which was used.
Mm-hmm.
And those are some of the challenges we are having with whether embassies can truly be laid, my lord, or rather whether it will not have been proper.
Just highlight, for example, the ones you're talking about. I'm looking, for example, at number 4. Notice of motion, prayer number 4.
Yes, my lord.
Is that one of them?
Complete Kian's logs, which, yes, those kind of things, my lord. Complete Kian's logs, Kian's servers.
Yeah.
My lord, we would have wanted you to hear the witnesses so that you know whether there is anything which is questioning the Kian's logs.
The witnesses have already testified through their affidavits.
Okay, my lord. It's okay, we can find
Let's do the application.
Yes,
Because it is open to me to give directions.
yes,
Having heard what the application is saying and
Yes.
what the parties argue,
yes,
I can still say I don't think
yes,
that we are yet ready
yes.
to deal with the Kim's issue. Let us proceed for hearing.
I hear you, my lord.
What I don't want is for us to be having applications coming up again during trial.
Okay.
Because we are going to, today, we will discuss when is the last application going to be made.
Thank you, my lord.
Okay. So that we have a roadmap. When we set dates for trial, it's just trial. We will not be having applications pending as far as possible. So let's retain the orders the way we have given them. 7 pages of submissions with authorities annexed, duly highlighted. Then the second application, we have already given orders or directions for it, and we concluded that. Is there something that we did not deal with in the second application, the one that came up this morning?
That one we had already concluded.
We had concluded.
Yes.
All right. So for this particular case, I don't think we have any other applications.
There is, my lord.
Yes.
There is an application by the fourth respondent.
Oh, the one that was filed today.
Yes.
This is a motion for, this is the one for striking out.
Yes, my lord.
But you want to strike out the whole petition on a question, on question 1, which we agreed is an issue.
No, my lord. It touches on all the issues, even the irregularities.
Okay.
Yes.
Maybe council can just supply us with the soft copy. I think he has my number, so that then we can just have a look at. Yeah, he sat my office in the morning when I was here.
I see in your relief, even to the response. In your response, your relief is that the court lacks jurisdiction.
Yes, my lord. That's our.
Okay. I don't quite capture it, but maybe you will elucidate. So we can take directions on this one.
Yes.
This is the application dated yesterday. It's dated 14th January.
Correct, my lord.
Yeah. The fourth petitioner's application dated 14 January. Directions, respondents, 1 to 3.
7 days.
You file and serve a response within 7 days of today's date.
Yes, my lord.
IBC,
Can give us the same duration, my lord?
you want to file submissions?
Yes, my lord.
How much time do you need for submissions?
My lord, you can give us 3 days, but we'd also seek leave for further affidavit in case they raise issues that we have not addressed.
In their response.
Yes.
Why don't we give you the liberty now?
That's okay, my lord.
Applicant to file a response to the reply, if any, within 3 days of being served. In which case, I'll now ask you to file your submissions together with your reply.
Correct, my lord.
Both respondents to file their submissions within how much time?
7.
7. Petitioner. The lead counsel, you are not speaking. The counsel who's speaking a lot is
Sorry, madam.
busy.
We were consulting on how we will help the court. My lord, I think we can take 3 days. 3 days.
Within 3 days of being served.
Yes.
Respondents to file written submissions within 3 days of being served with the applicant's submissions. Written submissions not to exceed. How much time do you need for this in writing?
Maybe 7 pages. my lord.
7 pages.
Yes.
This is a small application, I thought. Although it's a for striking out.
Yes. That's why we need that.
7 pages. Written submissions not to exceed 7 pages in all cases. To which authorities? Duly highlighted. shall be next. Is there any other application pending in this matter? I'm not aware of any. Would you be agreeable to hearing both, all the applications on the same day?
Yes.
Yes.
Yeah?
Yes.
So that you're not also coming up and down all the time?
Yes.
Or would you be happy to do it virtually? Does that make it easy?
Yes, my lord, being applications,
Mm.
we can highlight. Furthermore, we'll have found submissions anyway.
Yeah.
We can highlight virtual applications. We can come here for the hearing.
Okay. There are those who may want to come physically. I can do hybrid.
Yeah, that's fine. Because, my lord, given the volume of documents and the documents flying left, right, center, perhaps even if counsel will be appearing virtually, let him just have one person here in court.
Just in case we need some.
Kamodo?
On our part, we shall be glad to appear virtually. We'll be able to furnish any document Mr. Waruta will require on the spot, virtually, because it's an application. But for the hearing, then we can be sure physically.
Okay. So I'll do it hybrid. Those parties who want to come here physically can come physically. Give me a date for the hearing of the applications. There are now 3 applications.
On the 12th of February.
What kind of a day is that? Thursday, 12th of February. Is that agreeable to the parties? Any party that's for which that date is inconvenient?
It's okay. It's okay with me, my lord.
Okay. IBC is okay. Kamoto is okay. Twelfth of February.
My lord, we are requesting 17th if it's convenient and available to the court.
How does 17 look? It's a full day. Yeah, we'll have a problem because the court will be crowded with civil matters. So, and civil matters can go very long. 12, we have only 2 matters. So that even 11. 11th?
It's okay with me.
19th, because just getting that week is a bit.
Yeah. Unfortunately, we had already taken dates for the normal calendar
Very well.
because we didn't know about the petition being filed when we were taking dates last year. So we are trying to look for dates where you don't get inconvenienced.
Let's try the 12th.
You can try the 12th?
Yes.
12th?
Yes.
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 12th?
Yes.
All right, thank you so much. 12th February 2026. In our diary, will it be the first matter?
We have 2 more.
They're both hearings. Do you see how many witnesses there are? Because this will be heavy, there will be 3 applications. Can we have you at 9:15? 9:15 on that day?
Yes.
Yes.
Yeah. So there'll be 3 applications, so I expect it to be fairly lengthy. The session will be hybrid, both virtual and in person. All right. We look at witnesses. I don't think we can deal with witnesses for petitioner number, for the fourth respondent, because your witnesses you don't know yet. Is that what I had understood?
Yes, that's the position, my lord.
But for the petitioner, we have seen your witness. Or we now have a sort of schedule of the witnesses.
Yes.
I think you are 14.
Yes, there.
You are 14. Are there any that you wish to remove at this stage, who are repetitive, for example?
Not at this stage. Maybe after we do our internal reviews, we might, one or two things might change.
Okay, so 14.
But I will be glad enough to inform the court.
Okay,
Yeah.
14 witnesses to be reviewed. IEBC, I think we saw, what, 4 witnesses?
No, my lord, excluding the respondents, second and third, we are given 8. I know there is one in the list whose affidavit has not been filed. We are given 8. They are annexed at the tail end, my lord, of the second respondent's affidavit.
We have 10 witnesses other than the replying affidavit.
Yeah.
And then there was an indication of one by someone called Paul Wachanga, but that affidavit was not.
Yes, my lord. Yes.
What are you saying about them?
My lord, what I was hoping to do, or rather what I will be seeking to do, is because of the timelines. Basically, it was a matter of timeline. I will be seeking to file an application to put in 2 witnesses.
2 additional witnesses.
Yes.
So that there will be 12.
Yes, I could not be able to meet that because of the pressure of time.
Will there be any objection to that?
Yes, my lord. My name is David G. Council needs to be clear whether it's moving you in that application now or it's filing an application, because the base of my reading of the rules is that we are here for a pre-trial because pleadings are closed.
No, not because pleadings are closed.
Number 2.
Because petition number 1 forced me. Yeah, that's how petition number 2 comes in.
Exactly. Let me just clarify that.
Yeah.
While I want to give leave to respond.
Yes, my lord, maybe I can clarify to my learned friend, Mr. Ndegwa. I'm seeking leave to file an application to introduce those